Well, I think many of you who are regular watchers or listeners are quite familiar with my thoughts on judicial review in the Supreme Court, and certainly what's going to be happening as a consequence of this presidential election. We have 3 members of the Supreme Court who are over 75, I believe, 4 or 5 who are over 70, and at least one of them has cancer. The next president is going to make some serious decisions, and in fact, the one with cancer is Ruth Bader Ginsburg. Arguably one of the most liberal people on the bench, and if she gets replaced by a Romney appointee, you're going to see a court going so hard right. It's going to be, I think, frankly, it's going to be like the court was in the 19-teens. But Adam Freedman is with us, a conservative legal commentator, author of The Naked Constitution. Adam J. Freedman, FREEDMAN.com is his website. Adam, welcome to the program.
Hi, Tom. Thanks for having me on.
Thanks for joining us. First of all, the core stuff. I'm curious where we stand relative to each other on this issue. Where in the Constitution does it give the Supreme Court the right to strike down a law passed by Congress?
Well, the judicial power in the Constitution, in Article 3, extends to all cases arising under the Constitution and laws passed by Congress.
Right, but where does it say that a law can be struck down? It says that they should be the court of final appeals with regard to those. But where in the Constitution does it? You know, I'm assuming you're familiar with this history that until 1803, the Supreme Court never struck down a law. And in the first 60 years of this country, the Supreme Court only did it twice.
Well, until 1803, Tom, it's only a few years between the ratification of the Constitution,
1879,
the first Supreme Court, and then Marbury versus Madison.
That's 15 years.
Which asserted the right of judicial review. And that was look, Article 3 says relatively little about the judicial power. And I think that the power of judicial review is a reasonable interpretation of the jurisdiction of the Supreme Court.
Why would it be?
Extending to cases arising under the Constitution.
This is not what Hamilton was arguing, though, in Federalist 78, 79, 80. I mean, I agree with Newt Gingrich on this. Hamilton was saying that the Supreme Court would be the least malicious of all, the least able to be effective, and they have no control over the purse, they have no control over the sword. The purse is Congress's, the sword is the president's.
Yep.
They would be, and Jefferson, when Marbury came down, and of course Jefferson was president in 1803,
yep.
And when the Marbury case was laid down, he couldn't contest it because he won it, which put him in this really weird double bind. And because he had won, and so he wrote, this is what he wrote to Spencer Roane, who was Patrick Henry's father-in-law, or son-in-law rather, and a good friend of his, a federal judge in Virginia, on the Virginia Supreme Court. He wrote, and I quote, "If this opinion be sound, then indeed has our Constitution become a complete felo de se." That's Latin for legally a suicide pact. "For intending to establish 3 departments coordinate and independent that they might check and balance one another, it is given, according to this opinion, to one of them alone the right to prescribe rules for the government of the others, and to that one, too, which is unelected by and independent of the nation. The Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please." And then he goes on about how, absolute power is always destructive and it always destroys people and countries, and goes on about this. He says, "My construction of the Constitution is very different from what you quote. It is that each department is truly independent of the others and has an equal right to decide for itself what is the meaning of the Constitution in the cases submitted to its action, and especially where it is to act ultimately and without appeal. A judiciary independent of a king or executive alone is a good thing, but independent of the will of the nation is a solecism," an old word for blunder, "at least in a Republican government." Thomas Jefferson was furious about Marbury, went to his grave feeling that way, as were many, if arguably, if not most, of his contemporary. Virtually all of the anti-federalists, the Democratic Republicans, were very upset with John Marshall, the grand old man of the Federalists, deciding as he did in Marbury.
Well, I think they were upset with Marshall for a lot of reasons. I mean, he was definitely a staunch Federalist. There's no question about it.
But, I mean, there was such blowback in 1803 that you didn't see another decision in the history of the Supreme Court that struck down a law until Dred Scott, until 1856.
Right. Yeah, I agree, Tom. Look, I think that the power of the judiciary to even assuming the judiciary has the power of judicial review, I think the burden should be heavy before the court overturns a democratically enacted law. But I do think that judicial review is a reasonable interpretation of Article 3 because Article 4 contains the supremacy clause. If courts can listen to cases arising under both statutes and the Constitution, there is a hierarchy of laws. The Constitution is the supreme law, and therefore somebody has to have the final say about what's constitutional, in my opinion.
Well, in the founders' opinion, that somebody was the people themselves. And I commend to you Larry Kramer's book for more on this topic. I mean, we'll hop off this topic now if you'd like. But Larry Kramer is the dean of the Stanford Law School. Right. He wrote a book called The People Themselves. And Jefferson, Hamilton, who was no friend of Jefferson's in many ways, and many others, argued forcefully that if Congress passed an unconstitutional law, then the people themselves should throw those bums out and get a Congress that would fix that would remedy that. And historically, that's what that has been what has happened. The Supreme Court has been sometimes ahead of public opinion, sometimes behind public opinion, but basically always tracked public opinion, whether it was slavery, women's rights, minority rights. I mean, you name it, abortion, whatever. All these hot button issues. And I just, gay marriage, for example, you've got on your list here, gay marriage is going to be one of the issues coming before the Supreme Court for review. And Scalia just a couple of days ago said, well, gay marriage, that's a no-brainer. Sodomy's been illegal. Gay sex has been illegal for hundreds of years. Obviously it's constitutional to have laws against people, being who are gay, being married, or even having, even gay people having sex. And I'm like, what? Where in the Constitution does it say anything about gay people?
Well, it doesn't say anything about gay people, and it doesn't address marriage at all. I would argue it's one of the many issues that the Constitution leaves up to the states. And I would argue, for example, that the Defense of Marriage Act, which was obviously a bipartisan affair signed by President Clinton but heavily supported by Republicans, is unconstitutional under the 10th Amendment. It deprives the states of the right to define marriage, which was...
I don't disagree, but what Scalia wants to do is at the federal level say that, or maybe I'm misinterpreting what he said, correct me if I'm wrong, that at the federal level, the Defense of Marriage Act was actually constitutional, basically. I mean, Scalia's had many opportunities to knock it down. He certainly hasn't, so I'm guessing he agrees with it.
Well, he may be telegraphing what he would say if they decide to take that case. But if so, I disagree with him on that one. Again, not all originalists agree. What we agree on, and there are a lot of progressive originalists out there. What we agree on is the need to try to be faithful to the text of the Constitution.
But why? Because was this handed down by some great deity? I mean, we've got one of the most anachronistic election systems, for example. Our first past the post winner take all election system, which is in the Constitution, was a horror. I mean, James Madison realized it after the Constitution was written, and Federalist 10 spent all of Federalist 10 saying, don't form political parties because we've got a screwed up electoral system. John Stuart Mill came along in 1861, just as we were, in the Civil War, and figured out how to do proportional representation. Why should we look at this document and say, oh, well, they came up with this 235 years ago, it must be perfect?
Well, because it's a valid law, Tom. We don't take that living Constitution philosophy and apply it to any other law in the books. My view is, if you want to say you have a living Constitution, then, why not say you have a living speed limit and just go as fast as you can, or a living tax code?
Well, Nevada did that.
I don't have to pay money to the IRS anymore. And
Germany did that with the speed limit.
Say that.
Yeah. Okay. Adam Freedman, AdamJFreedman.com, the website, the author of The Naked Constitution. Thank you, Adam, for dropping by.
Thanks, Tom.
Good talking.